Yes, we have, Your Honor.
Are there any additions or corrections to that pre-sentence report?
No, Your Honor, I just want to make the court aware, Mrs. Addison, the deceased wife, would have been here today to impact. She had to go to the hospital yesterday. She's able to tune in, I believe, and watch us. The rest of Mr. Addison's family is here, and his mother is going to want to do victim impact at the end of sentencing.
Okay, thank you, Mr. Nichols. Any witnesses with regard to sentencing?
No additional witnesses, Your Honor.
All right, Mr. Lewis, you may make argument.
Okay. Judge, of course, this was a very tragic situation that has affected a lot of people. It was the decedent, Mr. Addison, his family, as well as Mr. James and his family. It was a situation where, this was a culmination of a long substance abuse history of Mr. James. The assessment that's provided in the PSI here says that there was about a 20-year relationship between Mr. James and different substances over a period of time. The one thing I can say is that once Mr. James went through this situation with his accident, he has been doing everything he can to try to better himself. He has got his high school diploma. He's was baptized and has definitely changed his ways in regard to his faith and continuing in that regard. He's also got some different certifications that he was able to receive dealing with OSHA, I think it was Men's University, things of that nature to try to better himself, Judge. Now, it's no secret he does have a long criminal history. That even included dealing with PCP, which is the same substance that was involved in his accident. And as well as, other serious offenses. I do want to address something as far as, I know there's some situations here dealing with the jail instances, and I know how the court proceeds or looks at the situation here dealing with those. Mr. James, if you look at these situations, majority of them did come from situations involving him and other inmates, as far as any type of fight or anything like that, which unfortunately some things he can't avoid. But as far as anything dealing with being disrespectful or anything towards jail employees or things of that nature, there's one situation I think that they were talking about that it wasn't an actual write-up, but it was notated. He has been a trustee over there for a period of time at the jail as well. Now, I do want to point out that, of course, some of those situations that Mr. James was able to do to better himself, of course, could definitely increase his earning potential as far as what he has, as far as his job situation. He does have significant family support. His brother is here today in the courtroom, who in any way is there to try to help him, including helping secure employment. My understanding is the plan, once he is able to be released, is for him to be moved to Houston, Harris County area, to be close to his brother, to help him with everything over there. Now, the PSI did have a recommendation for his different vehicles that support that's available to him through the probation department. What I will say is that everything that has been recommended, he definitely needs and will be better for him. We are not, and ourselves, are not asking for a specific number or anything like that. We just want him to be able to, of course, make amends for this situation as much as possible, which could include some of the restitution there. I think is the amount is over $100,000 for his restitution there to the family. Now, like I said, he has made a plan to try to better himself. He has a family that supports him. He is doing everything he can. He understands that this was a tragic accident, but one he was definitely responsible for. And what we're asking for is as much leniency as possible from the court, for him to be able to move forward with the situation, be able to make amends as much as possible. And I think he did provide a letter to the court as well to kind of speak to that as far as an apology letter that was to the family, his family, the family of the victim, as well as to the court, Judge.
And I've received that.
And so that's what we're asking for today, Judge, is for everything to be considered. We understand this is, you bring that person back. He can't just go back to make amends with Mr. Addison, but he wants to try to make as much of amends he can to society and do better going forward, Judge.
Thank you, Mr. Lewis. Mr. Nichols.
Your Honor, I think any consideration Mr. James is due was given when he got a 50-year cap. I have no hesitation asking the court to exercise the full 50 years. This case is one of the worst intoxication manslaughters. It's on video where he plows into Mr. Addison, who's at a stoplight on a motorcycle, and while trying to get away, runs over him and the motorcycle again. It's horrific, Your Honor. What is also just inconceivable to me is that a man who's on parole for several possessions of phencyclidine, PCP, finds himself behind the wheel on PCP again. And this time it ends in the death of someone. His criminal history is extensive. It starts with minor drug offenses, then a conviction for aggravated robbery, and then I believe it's 5 drug convictions all at the same time in 2020, for which he was quickly paroled out and on parole when this happened. The fact that he gets to make plans in his mind for a day he's set free, I find rather offensive, and I think the Addison family finds offensive. They lost a son, a brother, a husband. There's nothing we can do in this courtroom makes that better. And sometimes the justice system is a poor substitute for what people lost. I think the best we can do at this point is this man spend 50 years in prison where he cannot hurt anybody else due to his own selfish decisions and continued use of substances. It's in the pre-sentence report. He minimizes his own addiction, his own dependency. He even claimed he did not know how he could have gotten PCP in his system the day this happened, that maybe he touched a bottle and it transferred through his skin, and I find that reprehensible, Your Honor. And that's why I'm asking the court for that full 50 years.
All right, thank you. So, Mr. James, a couple of things that Mr. Nichols didn't say that I think are also extremely important is this isn't your first driving while intoxicated. This is your third. And so you didn't learn in 06. You didn't learn in 2017. 2017, you got your second DWI. You were given probation. It was revoked. I appreciate that you entered a plea of guilty because for myself and for the family, I'm glad we didn't have to see what it looks like this would look like on a video, because it is just horrible. And the fact that you are truly saying that you think you touched something and got PCP when you have had PCP cases over and over and over again, and you're on parole for possession of a controlled substance and you kill someone. It's a nightmare. Sure, go ahead.
Can I say something? You know, that night that accident happened, I've been clean the entire time I was on parole. Okay, I stopped off at a friend's house to give him some advice about what he was doing. And during that time, I did contact a bottle of his. You know, I was not high at that time at all.
It was in your system.
Yes, ma'am. And you know how I fight you.
At this time, based on your history, based on the nature of this offense, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter. I'm going to sentence you to a term of 50 years in the institutional division of the Texas Department of Correction. There will be a deadly weapon finding based on the indictment alleges a deadly weapon. You will receive credit on the sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement and I followed it, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're eligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. There's really so many other things I could say about how horrible this is, and rarely am I out of words, but I really don't have the words to say what a tragic circumstances based on your behavior this led to. Y'all can have a seat at council table for
Mr. Lewis. Mr. Garcia, come up, please, sir. Mr. Garcia, you tested positive for marijuana, amphetamines, methamphetamines, and ecstasy. Did you drive here? Oh, you're surprised about the ecstasy?
Yeah, I'm surprised about that.
Wow.
I did sweat the other relapse years ago.
Yeah. All right, so I'm going to find, obviously, that is a violation of your bond conditions. I also told you last week specifically that you had to be here on time. No, you were not here. And so I'm going to raise your bond in your case to $100,000. If you make that bond, a condition of it is that you have a drug patch on at all times, that you also have a GPS monitoring device and remain in Jefferson County, since you can't seem to get here on time. We'll figure that out. Talk to your attorney. You can go back with the bailiff. Himmler on Jason Harris. All right, Mr. Harris, this is 24 DCCR 2254. You tested positive this morning for methamphetamines and amphetamines.
I took a lot of powder pills for 3 days, and that's the only thing I think that was made a problem. I've been in Houston with my kids, and I ain't been around here right now. And I took a lot of powder powers red.
5 Hour Powers is not going to test positive for methamphetamine.
If you see it off to the left, I'm sure you'll see it. It's not, I don't do anything like that. I don't have money for that.
Well, all I know is you tested positive for methamphetamine. And obviously there's some concern because you were arrested while this case was pending, and Mr. Coleman figured that out. Hold on.
It was a traffic ticket.
Just, hold on.
I would just observe this, if it's paraphernalia, that's a class C, and normally those aren't arrestable. I mean, it is an arrestable offense, but normally it's just a ticket. So jail, I'm fine on the offense.
If you're on bond for a felony, you should. I just asked you not to say anything else right now, okay? I'm just checking on something.
Let her check it.
Obviously, Google and AI is not the end-all be-all, but it is unlikely to cause a positive result on a standard drug test. A 5-hour energy drink does not contain prohibited substance like THC, opiates, or amphetamines. Extremely rare and undetected issues involving cross-contamination during manufacturing would do it, so I don't think that's what we're worried about today. I'm going to grant the state's motion to raise your bond based on the fact that you tested positive, based on the fact that there was an additional arrest while you were on bond for a felony offense. I'm raising your bond in your case. It's currently set at $30,000. I'm going to raise your bond to $75,000. I'm going to order as a condition of that bond that you have a drug patch at all times, that you get it changed out as you're supposed to. Your case is still set for trial to begin with jury selection on Monday, and is everybody ready for that?
Yes, please.
All right, I'll number the case. If you're in custody, we'll have you brought over for trial. If you're not, then you can talk to Mr. Kimler this morning, okay? All right, you can go back with the bailiff. Mr. Kimler, on Brianna Clayton, you can come up, Ms. Clayton. All right, Ms. Clayton tested negative, which is obviously good, and,
No 5-hour energies.
yeah, you never know about those energies.
Still,
Ms. Clayton, in cause number 25, DCCR 0446, you were previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
defense agent.
Yes, Your Honor.
Are there any additions or corrections?
No from defense.
Not from the state, Your Honor.
What is everyone's position with regard to the recommendation in the pre-sentence report with regard to her addiction issues? The recommendation is ISF followed by JCDI program.
Again, from the defense, Your Honor, the treatment is a continuum, I suppose, and since she's demonstrated at least today that she's drug-free, then I would suggest the court only ISF in advance, just see how she progresses on probation. Maybe perhaps with a drop program.
Well, she's going to go through JCDI for sure,
JCDI.
if, at a minimum. Mr. Nichols, thoughts since
I
she
would ask
tested
at least for
negative?
JCBI, Your Honor. She's still underage, but she has a drinking problem and needs to get that dealt with, treated, or under control. And she also smokes marijuana regularly. The facts on this case, she and her friend were heavily intoxicated,
Yeah.
fled from police, lucky it wasn't a crash,
It could have been terrible.
tried to hide out from police
Yeah,
around a...
I know, yeah.
And it could have been a lot worse. And I'll just tell the court from reviewing the video, at least that night, they sure thought it was hilarious. She needs to grow up. She needs to take a little more serious once getting her here in felony court.
Yeah.
And I'll...
You understand it's not funny. I mean, no, I understand that right now, and people do that.
But that night, yeah, I do regret everything that night.
So here's the thing, and the seriousness of this is that if you don't do what you're supposed to and get your life on the right track, which is what everyone wants. You're young, we want you to be successful. You're going to get a probation today where you don't have a felony conviction on your record, and if you complete that probation, you're never going to be a convicted felon. But if you violate and you don't take advantage of the programs that we're going to give you, it's going to be difficult because you're at an age where all your friends are going to be doing things that you're not going to be able to do. But the alternative is prison for up to 10 years. So you need to think about that every time somebody says, oh, just come on out with us and do whatever, and your answer is going to be, I'll do that in a few years when I'm not on probation, right? Because I don't want to go to prison for 10 years. So I am going to the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $250 fine. I am going to order that you enter and successfully complete the ISF substance abuse track, but I'm going to hold that in abeyance. That is an inpatient 90-day program. So if you get in, you're going to be required to go to JCDI and complete that program. And it'll give you the tools, hopefully, that you need to stay sober. If that's not enough and you need something more, it's already ordered. A warrant will go out for your arrest, you'll go into custody, and you'll go straight to that program, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck to you, ma'am.
Thank you.